Well, there's over 152 cases against the Trump administration, and the people that are suing him are winning at an extraordinary rate. They're batting 900. Occasionally, the Trump administration wins here and there, but overwhelmingly, federal courts are protecting our democracy and our rule of law against Donald Trump with dozens and dozens of temporary restraining orders, preliminary injunctions, and the like. Occasionally, Donald Trump gets a rare win. We just had one, came on the heels of 4 losses in a row, so he was 4-1 for the week. But there was a win in a 2-1 decision. A panel on the D.C. Court of Appeals, led by Henderson, Millett, and Walker, decided 2-1 to let Donald Trump effectively put out of business the Merit Service Protection Board and the National Labor Relations Board by allowing him to fire people, even though this was a congressionally created executive agency. And because they don't have a quorum, they can't work anymore. So take that, labor unions that didn't support Kamala Harris. You now no longer have the one agency, the National Labor Relations Board, that protected your clients and your union members' interests. And take that, the union that supported the federal workers, because you don't have the Merit Service Protection Board any longer to protect federal workers, because that's out of business. Without a quorum, firing those 2 people that was just allowed by the D.C. Court of Appeals, they can't operate. That's what Donald Trump wanted to accomplish. And now we're going to have to see what the United States Supreme Court does. And so we have another decision, just a transition, batter up, transition, same 3-judge panel, Henderson, Millett, and Walker, except now, whereas Henderson was like, I'm not letting you exercise war powers when there's no war, so sit down. Here, when Donald Trump decided to decapitate and put into mothballs the National Labor Relations Board and its expertise about labor and collective bargaining matters and illegal practices in the workplace, and the Merit Service Protection Board, established to protect federal workers in the civil service area that was reformed in the 1970s. And he decided, I got a way. I'll get rid of the quorum. I'll fire the Democrats. I won't replace them with anybody, and they don't have a quorum, so I don't have to worry about it. No more National Labor Relations Board and no more Merit Service Protection Board. Well, multiple judges, starting with Beryl Howell and Rudy Contreras, and at the time, Amy Berman Jackson, decided, no, you can't fire the special counsel, the Merit Service Protection Board, or the National Labor Relations Board board member, because Congress established them as, yes, they're in the executive branch, but they are independent, they are bipartisan, and they don't exercise enough executive power to run afoul of a long line of cases starting in the 1930s, with a case that you and I and the rest of us refer to as Humphrey's Executor, named after a case. And that case said, as long as this thing doesn't exercise that much executive power, and it was set up bipartisan, and it does these administrative things, even adjudicative things, it can't be fired at will by the president unless there's cause. None of these people, there are no cause. The only cause was he didn't like the color of their party, if you know what I mean. They were blue, but they're also women in black. So that case, which was reaffirmed in 2020 in a case called Celia Law, that is 90 years of precedent. Now, the 3-judge panel, again, Henderson flipped this time, the Bush appointee, and sided with Walker, the Trump appointee, and decided that they're going to throw over the game board of 90 years of precedent and say Humphrey's executor is questionable. And it's not really, it's really the outer boundaries, and find these boards are exercising more executive power than the Humphreys court had anticipated. And therefore it violates the separation of powers. That's how they got there. Millett, the judge who in the other case said Nazis have more due process, she's livid. And in her order, her dissent, she said, you are the only federal court to have ever found, after Humphreys in 1937 or 35, and after Celia, and all the times the Supreme Court has affirmed it, to find that a president can fire without cause people with agencies and these do not operate in the world of exercising too much executive power. They have barely power at all, but they are important. And all you're doing, she called it out, is you're letting Trump remove the quorum. So there's not enough people to operate, effectively incapacitating them, decapitating them, despite the fact that Congress has funded them and established them for a reason. So it's the executive branch who's, if anybody's violating the separation of powers, it's the executive branch. And the status quo, as you started the hot take or the podcast with, the status quo is keeping them in their chairs. But now by a 2-1 decision, they're fired again from their roles, meaning these two entities stopped existing. And the parties, the plaintiff side, the appellant side, have asked the court to stay their ruling to give them an opportunity to go out to the United States Supreme Court, and we haven't gotten a ruling on that yet. But you can see, you and I half joke a lot about, tell us who the judges are, and we can tell you what their judicial philosophy is and how on a lot of cases they're going to come out. And so when I heard Henderson, who'd been on a wrong side of a couple of other cases involving Donald Trump in the past, was the swing vote here, if you will. Mm-hmm. So you can see where she's at. No on war power, phony war powers. Okay on unifying the executive branch and letting Donald Trump do whatever he wants with all these agencies.
You know, this is where I see a lot of quote unquote conservative jurists kind of over intellectualize us into fascism and view this as some kind of fascinating thought experiment into how smart they are and these kind of esoteric ideas. And it's very weird, because you would think that the same panel that basically says, hey, Trump, you're acting as a dictator by kidnapping people and sending them to concentration camps, would also be the same people who go, hey, you're acting as a dictator by firing these people in independent boards. But you see where I say they over-intellectualize that the issue is not that they're saying, Trump, you have a right to fire the people. Trump didn't win the case. What Trump won is that these right-wing judges who ruled against him in the other case, in the 2-1 decision, were basically like, what is to be or not to be? That is the question, right? It was, what is the status quo? Is the status quo now, because they're fired, the fact that they're fired so they don't return? And thus, if we just hermetically seal what's happening, you could still fight, but it'll take you 2 years to fight for your job back, and you may ultimately win the merits. But the status quo is the termination, or is the status quo the fact that these people had a job and now they no longer have a job, which is what the people who were fired were arguing. The status quo is return us to the job. And so you could understand the thought experiment, if this was a law school class, argue this. Well, the termination happened. Thus, once you go to court, ergo, they're fired. So the status quo before they filed is that they're fired. But you're like, okay, well, now you've just justified dictatorship, you freaking idiots. And that, to me, is a lot of the issues with these John Roberts style conservatives who act like they're so smart. You know, it's like, watching the Harlem Globetrotters play basketball. And it's like, okay, but you'll never actually beat the freaking team if you just spin the ball around on your fingers, go, like that's not how you actually beat the dictatorship at the end of the day. It's like, I get it. You're smart, but you just made a freaking stupid ruling.
Do you think, let me ask you, I totally agree with that. Do you also think that Henderson, knowing what she ruled on Wednesday, do you think this was a makeup call? The umpire continuing baseball saying, wait, that guy was out at first base. Well, you think it was a makeup call by her to give the Trump administration one?
It's their bizarre. I saw it in law school. I was in Paul Clement's class in law school. Paul Clement was a professor who taught clinics at Georgetown Law Center. And so, you can have a guy like Clement who's like, I'm going to fight for the law firms against this overreach. But, the Patriot Act does allow a lot of torture. The unitaries, it's just I do think that I don't want to hold, this over the head of Mayor Eric Adams. So I'm going to think there should be a full dismiss. It's why I've always said you can't run a media network or anything trying to actually court these people and be like, come on, we're the pro-democracy crew. What you have to do is just be in your own lane, speak the truth every day. And if they want to join because they feel shame that they're not part of it, then they'll join. But you can't like actually put your hopes into some of these people because they'll always let you down when you find out.
So until my next reporting, you're here on Legal AF. We break it all down for you. Follow us on Wednesdays and Saturdays at 8 p.m. Eastern Time as we sit at the intersection of law and politics on the Midas Touch YouTube channel. And then pick us up on all audio podcast platforms of your choice. So until my next report, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.